Towards the end of the 18th century, a new type of physician, the mad doctor, began finding his way into the courts as an expert witness for individuals claiming that they were mad and therefore could not have been held criminally responsible for their actions. This was straight up common law, where an actus rea, a criminal act, had to be accompanied by mens rea, a comprehending mind. In other words, the person accused of a crime had to be aware that they were doing something wrong. If not, they couldn't be held responsible for what they'd done. Through most of the 18th century, the courts insisted on total madness, the idea that an individual behaved like a wild beast rather than a reasoning human being. Several attempts have been made in the courts to introduce partial madness, a madness that occurred sporadically but with little success. Typical was the fate of Lord Ferrers, who had murdered his servant. He attempted to claim that he suffered from a partial insanity that was hereditary. He even got the Bedlam physician John Munro in to testify that this was the case, but to no avail. His peers found him to be an angry, violent man fully responsible for his actions, and he was duly executed. But just at the time that Locke's views were beginning to permeate the thinking of mad doctors and physicians more generally, partial insanity and delusion became accepted by the court. Now, remember, Locke had made the point that madness was, in effect, delusion. It was a failure to associate concepts properly. What was in reality completely and utterly wrong, seeming to the deluded individual to be right. This meant that hypothetically you could be delusional and still understand the consequences of your actions. It was the case of James Hadfield in 1800 that shifted the law's views of culpability. And it was his attorney, the brilliant Thomas Erskine, who used cutting-edge ideas from the emerging field of alienism to exculpate the defendant. Hadfield was an old soldier that had been severely wounded during the French Revolutionary Wars. He'd been slashed around the head by a sabre, wounding him no less than 8 times, and it marked a significant change in his personality. He was for many years a prisoner of war, but on returning to England, he fell in with a millennial religious cult, and through them came to believe that the second coming of Jesus Christ would be brought about if he was judicially executed. And what better way to get yourself executed than trying to assassinate the reigning monarch? Actually, as Eigen maintains, counterfeiting money would have been a far better route.
I'm standing for the king!
Who are you?
My name is James Hadfield, and there is a great deal more and worse to come.
That clip doesn't really do justice to what happened, but then Garrow's Law seems to be an attempt to redo Silk in the late 18th and early 19th centuries. On the 15th of May 1800, Hadfield attended a performance at the Theatre Royal, Drury Lane. During the national anthem, he discharged his pistols at the king, but missed him. Wrestled to the ground and arrested, he was tried for high treason, which is what allowed him to have a defence lawyer like Erskine. Erskine's defence was effectively that the older legal definition of madness should be ditched, because While it was clear that Hadfield was fully aware that what he was doing was legally wrong, his actions were based upon the delusion that he was morally right, that his execution would lead to the second coming of Jesus Christ, ushering in the Last Judgment. And duly acquitted he was, found not guilty on account of insanity at the time of committing the crime. Now, among the many witnesses to come forward to give testimony about Hadfield's mental state were physicians and surgeons who had examined him or who had known him in the army. But their testimony was perfunctory and brief. The physician Crichton saying that Hadfield's madness would come and go. That was about it. In fact, it was Erskine's defence, combined with the many non-expert witnesses who came forward to testify about the defendant's change in behaviour after his near-fatal head wounds, that resulted in his acquittal. Now compare this to the trial of Edward Oxford in 1840, a very similar crime. On 10th of June, Oxford positioned himself by the road at Constitution Hill near Buckingham Palace. As the young Queen Victoria drove by in her phaeton carriage, he discharged 2 pistols at her. Either the pistols weren't loaded with bullets or he missed. Right away through the trial, whether the guns were loaded with shot or not remained contentious, and the jury was unconvinced of the prosecution's case that they'd found bullet marks in the walls opposite where Oxford had shot. But insisting that the guns were loaded, the prosecution maintained that Oxford had committed a treasonable act, and so he was put on trial for his life. He obtained legal representation through the Society for the Abolition of Capital Punishment, and Sidney Taylor, a prominent member of that society, was appointed as his chief counsel. Taylor proceeded to contest Oxford's guilt on the ground of insanity. It wasn't just the fictitious secret society Oxford had made up, complete with imaginary members, Young England. It was also the fact that madness seemed to run in the family. Witnesses record the inconsistent, violent and occasionally downright mad behaviour of both his father and grandfather. Furthermore, medical witnesses claim that Oxford's mother walked the tightrope of sanity, occasionally falling off. In the defendant's favour was his seeming indifference about what he had done. "I might as well shoot at her as anyone," was his response when asked why he wanted to kill the Queen. Edward's behaviour had as well been strange ever since he was a small child, his mother testified, laughing inappropriately, occasionally violent and destructive, repeating chunks of Shakespeare, particularly Macbeth, for no good reason. Sometimes okay, sometimes not. But what is striking about the Oxford trial is the amount of expert testimony given by medical men about his insanity. First up, Dr. John Burt Davis, physician and coroner in Birmingham, who had treated Oxford's father for laudanum poisoning, asked, supposing a person in the middle of the day, without any suggestive motive, to fire a loaded pistol at a Majesty passing along the road in a carriage, to remain on the spot, to declare he was the person who did it, to take pains to have that known, and afterwards to enter freely into discussion and answer any questions put to him on the subject, would you refer such conduct to a sound or unsound state of mind? He categorically replied, yes, upon his oath. The next medical witness was Dr. Hodgkin, almost certainly Thomas Hodgkin of lymphoma fame. He maintained the hereditary nature of the insanity that afflicted Oxford. He then, being pressed about the onset of the insanity, claimed that people like Oxford suffered from a lesion of the will. Let us pause here for a moment and consider that expression. Lesion is a term that had become very popular in medicine with the emergence of pathological anatomy in the latter part of the 18th century. Clinical medicine was founded upon the idea of collecting the symptoms of patients while still alive and then correlating those symptoms against the lesions found in the body post-mortem. This led to the redrawing of the map of disease, and it was the method favoured by Hodgkin. So for Hodgkin to come out and suggest that someone might have a lesion of the will, a concept that can only seem metaphysical to us, must have given considerable force to the defence. Lesion of the will had been conceptualised in France, where moral therapy found its earliest systematisers. It was also known as moral insanity, and its symptoms were found in individuals who, in most respects, functioned normally, but for no reason whatsoever got the urge to do things, impulses that could not be resisted. The suggestion was that the will of the individual was so impaired that the mind's innate reason could not counteract the urge. Or, as Hodgkin put it in his evidence, I mention lesion of the will as a term under which a highly reputed writer on insanity has chosen to designate a form of insanity in which sometimes flagitious, which means criminal, acts, sometimes only eccentric acts are committed. It means more than a loss of control over the conduct. It means morbid propensity. Moral irregularity is a result of that disease. Dr. Chown at the Charing Cross Hospital confirmed Hodgkin's claim, while John Fernandez Clark, a medical journalist and general practitioner who had personal experience of treating Oxford and his family, was able to confirm that Oxford's madness was hereditary. Clark relied upon Esquirol's treatise on madness to direct the court to the age when imbecility, as Clark called Oxford's condition, was likely to set in. Oxford met these criteria. The most prestigious of the medical witnesses was John Conolly, the superintendent of Hanwell Asylum. He spoke with the authority of a man in charge of 850 lunatics at the Middlesex County. He was as good as it could get in terms of English expertise on madness. Conolly had been approached by Oxford's defence to fulfil this role. On examining Oxford, he'd noticed a depression in the skull. Reading out his notes in court, he emphasised the imbecility of Oxford, and while not mentioning the phrases moral insanity or lesion of the will, his testimony could easily be read back onto that of Hodgkin and Chown. And this is what he said. A deficient understanding, shape of the anterior part of the head, that which is generally seen when there has been some disease of the brain in the early period of life, an occasional appearance of acuteness, but a total inability to reason, a singular insensibility as regards the affections, an apparent incapacity to comprehend moral obligations, to distinguish right from wrong, an absolute insensibility to the heinousness of his offence and to the peril of his situation, a total indifference to the issue of the trial. Acquittal will give him no particular pleasure, and he seems unable to comprehend the alternative of his condemnation and execution. His offence, like that of other imbeciles who set fire to buildings, etc., without motive except a vague pleasure in mischief, appears unable to conceive anything of future responsibility. The Old Bailey Sessions papers, from which most of the accounts of the trial are derived, do not give a sense of the drama or the cut and thrust of the court. Clark would later claim that the prosecution had gone in really hard with the medical witnesses. You don't get that sense reading the transcripts. Neither do they give Lord Denman's summing up, which was equivocal, particularly about the medical evidence. He admitted that at the very least Oxford's behaviour bordered upon insanity, but the extent to which his father and grandfather had been mad was questionable. Furthermore, as Denman was at pains to emphasise, with respect to the evidence of the medical gentlemen, it was to be listened to with all the attention which their knowledge demanded, but the common sense of the jury must be the arbiter of what they saw. There might be cases of insanity in which medical evidence as to physical symptoms was of the utmost consequence, but as to moral insanity, he, for his own part, could not admit that medical men had at all more means of forming an opinion on a case than were possessed by gentlemen accustomed to the affairs of life and bringing to the subject a wide experience. In the end, however, the jury was convinced of Oxford's insanity. Whether it was the evidence about his family, the existence of his young England delusion stroke fantasy, the medical testimony about moral insanity, or all of the above, is hard to tell. But having received instructions from the judge in no uncertain terms, they were convinced that at the time of the crime, Oxford could not tell right from wrong. He was therefore found not guilty on the ground of insanity. We will never know why jurors make the decisions that they do, and so we will never know the extent to which the expert medical testimony provided at Oxford's trial was instrumental in his acquittal. But we can say three things about this. Firstly, the fact that medical experts were being let into the court to present testimony, expert opinion, about culpability and responsibility, inherently legitimised the ideas they brought into the court. Secondly, their views were contested by some legal experts who were dubious about diagnoses like moral insanity, and there were some concerns about the nebulous qualities of this diagnosis. And thirdly, this was part of a process of making up a new kind of person, a person that would evolve into a homicidal maniac before morphing into the psychopath. It also indirectly opened the doors to another possibility, that criminals were born, not made, and consequently should be treated rather than punished. In some regards, the law would have its revenge 4 years later, when the rules around criminal responsibility were tightened up to prevent the Oxfords of the world being acquitted. Although, as the acquittal consisted of being detained at the monarch's pleasure, the verdict generally swapped the speedy death of capital punishment for the slow decay of a lifetime in prison. Now, as an aside, Oxford was eventually released as sane in the late 1860s, on condition that he left England. He emigrated to Melbourne, where he made a decent life for himself. Queen Victoria, however, never forgave him and rued the fact that he was not hanged.